All right, good afternoon, everyone. We are back on the record in State versus Brooks. Appearances are as they were this morning. I will let the parties know I have taken a look at the submission that the parties worked on while we were off the record, the meet and confer. That's what I will refer to it as. I have not had an opportunity to look to see if anyone has filed any written objections. Has anyone done that I just haven't seen? From the state?
No.
From the defense?
No.
I did just email to the court. We had changed question 31 and updated the table, and I had not adjusted that yet in the draft that was sent out before lunch. So I did insert the new question 31 and the corrected table that we came up with during the meet and confer, and so that's now been emailed to the parties.
Is occupation the last column?
Yes.
So other than that, I didn't work on formatting a lot. I just really was trying to get the page numbers down, and I printed off 19 of the pages because then the remaining pages were the blank lines for additional. So I'm going to do is I'm going to print this off for each one of the parties. You'll get all pages. Actually, it'll be 1 through 19. I was able to customize it. While we're waiting for that to be printed, do the parties anticipate needing discussion on any of the questions that are in the proposal that's currently before the court? From the state?
Yes.
And from the defense?
Yes.
I can tell you that in my review of the submission, there are some questions that I have questions about. Some of the questions I have would be content related. I don't know what the parties' specific questions are. You would know that, but in light of what your objections or issues would be, is the defense making a renewed request to have this part of the hearing closed?
I think based on what our understanding of what the state's issues with this are and what ours are, that can be done without closing it, because that's not really getting into the current content.
What I can, let me ask the state first before I tell you what questions I have questions about, but. Should have 19 pages. Thank you. From the state?
Judge, as we were going through this, I think the biggest issue that came to be towards the end of our work here this morning was related to what we were going to tell the jurors about when the trial would occur. And Attorney Perry had mentioned at the outset of the hearing this morning that he felt the October trial date was unworkable. Our biggest concern is that if the trial date is going to be moved, that number one, first and foremost, we have to give notice to the jurors if we're going to consider, the victims, if we're going to consider moving the trial date. But number two, as I understand it, in some initial discussions with the defense counsel, that they'd be looking to delay this case 1 year or more, in which case sending out this questionnaire next week or next month is a waste of time and money, in my opinion. So I think that's really the biggest sticking point that we have at this time.
I agree. If the trial's not going to be held in October, there are some practical implications to this process. I did reach out to the Director of State Courts office in anticipation of this issue to ask them about the master list and when that is generated. And what I was told is that list would be available October 1 for 2023. So assuming, without making any decisions, of course, that that is the request from the defense, there would be a practical issue if we would not be able to send questionnaires out now, because it would have to be a 2022 jury pool.
2023.
To do it now would require
right,
2022.
Yes.
If it got bumped, then we'd have to wait until that master list is available. Again, that would be October 1. So I agree with the state that there are concerns regarding that. Now, I don't have a motion before me today. I do appreciate the defense alerting the court and the parties to that. I agree that there needs to be notice to victims who could weigh in on that. And I certainly would want more information as to why the defense believes it would not be in a position to try this case in October. What is that? June, July. 6 months from this Friday. That is a significant amount of time for the parties to prepare without knowing more, for example, on what the expertise that was referred to this morning, or about whether it's impossible to view the discovery that's been made available. And then related to that, obviously we haven't had any kind of exchange of witnesses. I know the state mentioned this morning over 100 known victims and thousands of witnesses, but I don't know to what extent you would be calling all of those, because at the last hearing you indicated the state would need about 2 weeks to present its case.
Yes, I'm sorry, when I was referring to witnesses, I was referring to that term generically as to who was present at the parade, not court witnesses.
Thank you. I appreciate that clarification. I think we can certainly move forward with the sum and substance today, and if there is a request to adjourn the trial, that needs to be made by motion quickly before any questionnaires would be sent out, because there is a significant expense involved in this, and I want to be mindful of the taxpayer resources, but also mindful of Mr. Brooks' right to a fair trial and his team being able to be fully prepared. But I do intend to at least get through the sum and substance. What I'll tell you before if there is any renewed request, to close this part of the hearing, my questions will be related to questions and on page 7, because some of the numbers I know repeat, but question 40 on page 7. The question directly below that is numbered 74. Again, that's some of the formatting error. And then on to page 8, questions 41, 42, 43, 44, and 45. And whether those would even be relevant in voir dire on a trial that, from my perspective, there has not been the entry of a special plea, and that's typically where those questions. So I think we can talk about that without divulging the content, but that's the questions I have. The remaining things really are some verbiage that I don't see any issue with being on the record in a public forum. Anything on that then from the defense?
Related to closing the hearing
Right.
to discuss these questions? No,
Right.
we don't have any objection to keeping the hearing open to discussing these questions.
From the state.
We agree.
All right then, very well. So do both sides then have the 19-page printout from Teresa?
Yes.
Yes.
So my first question to the parties is, I know throughout the use of this questionnaire, there are many questions that reference family. Do we need to define that for the jurors or change that to immediate family? I just want to make sure that the jurors have the same understanding. I think generally speaking, immediate family, people would understand to be your spouse, any children, and parents. Family generally could be aunts, uncles, cousins. So again, do we either provide a definition in the instruction or somewhere within the questionnaire, or change this to immediate family? State have a position on that.
We don't. It was discussed amongst us this morning, Your Honor, and I think the defense wanted it broader as opposed to limiting it. We discussed the same topic on the issue of friends. Do we say close friends or just say friends? And I believe the defense wants the broader terms used.
I think where it matters, Judge, is that the opportunity for explanation. And so if somebody answers it and then the explanation is about their second cousin twice removed or whatever, right, then we would read that a different way than if it was, you know, the grandmother who stays in my house kind of thing. And so when we talked about, you know, I think thinking about providing a definition, especially with, you know, whatever the living situation might be, it starts to get complicated where you are maybe excluding some circumstances of families, you know, extended families living together.
Do you think then, for example, look at on page 3, question 21, there is the portion of that answer where they can provide an explanation that something should be said. Please briefly explain, including the nature of the relationship or the degree of kinship or anything like that, so they are tipped off as to what it is that we're looking for? I realize we'll have an opportunity for those who ultimately make the cut, shall we say, to come in, and that's the traditional jury selection and questioning where you would also be able to ask those follow-up.
Do you mean in question 21, are you looking on page 3?
Page 3, question 21, it references family. So I am asking, so when we tell them, if you checked any of the boxes, please briefly explain, including the degree of kinship or the nature of the relationship you are disclosing, or leave it as is.
So you're asking if we should add, explain
The nature.
the nature of the relationship?
Correct.
That, we can add that, that's fine.
It's fine.
If yes, comma, explain the nature of your relationship, and then leave the other 3 follow-up questions the way they are as well.
So just add a comma after explain, including the nature of the relationship.
Sure.
From the state, any objection to that?
I don't object to it, Your Honor. I think generally we had a different philosophy on how to approach these. I think the defense favors open-ended questions, whereas I favor, asking, who was this person, which field did they study, when did they study it, and for how long? Because if you say briefly explain to me, you're going to get a wide variety of answers and maybe not the information we're looking for. But that was, throughout this process, a different approach by the state and the defense.
Is there anything you would add to that sentence that tells them to explain that would maybe trigger them to respond more specifically that you would suggest?
Yes, those questions.
Other than the
Which field? Because, I mean, again, some of these are terms of art for us that have, pretty significant meaning to us, but some of it is subject to interpretation, so legal field, what does that mean? It's very broad, and I understand there's a benefit to keeping it broad, but it also results in ambiguous answers.
Although I think that question mimics verbatim what the state had in their original
It
proposal.
is, yes, yes. I acknowledge that. And that's,
Well, I think then, if we're going to keep it general, then, I'm just asking whether the parties want to look at that. I'm happy to leave it general with, please briefly explain, and leave it for the follow-up voir dire questions for those that come in.
sure, and this probably wouldn't go to much to do with the change of venue anyway, so.
Agreed. All right, then, I'm just going to go in numerical order of the pages. So on page 5, when we ask them about their prior jury service, I would like to say foreperson/presiding juror, and I do that because in Wisconsin, they're instructed to select a presiding juror, and I just thought that may help people as they fill it out who have that kind of experience.
Sure, that's fine.
Any objection from the state?
No.
All right, we'll make that change. All right, so Attorney Keyes, I have this chart for question 31, at least what's labeled 31 on page 5. So is that to eliminate designation and have them write the person?
Yes, because I think what we had discussed, both sides together related to this chart, was that we don't know people's household living situations, and so we want to catch as many living situations as possible. Previously, we had listed out self, spouse, and then children, and then father and mother, but that may not be somebody's living situation. And again, we want to just try to catch all close, like, living situation relationships. So that's why we left it more open-ended, to try to catch more issues.
That makes sense. We may want to add, if you need more space, please use, I know that's in the beginning part, but
And we could add that to every question,
you could.
which is redundant.
But you're satisfied with just the 4 boxes, and they can list out any additional on the back pages that we provide?
There are 8 boxes that go on to.
Yeah, you need to look at the updated one, please, Judge.
There are more on the next page that didn't.
No, I don't think, what you printed out for us, Teresa, doesn't have the updated chart.
I know, I gave her a print of
Oh,
what
oh.
Attorney Keyes had sent me.
Okay,
but
thank you.
It goes into,
There's like another 4.
So 8
on the
boxes?
next.
Okay, very well.
It's 8 rows.
Okay. All right, that seems good then. All right. Then my change where it said spouse to add significant other is not needed. All right, I don't have anything else till page 7, and these are the questions that I advised the parties about previously as to whether there is a need for these, given that there has not been the entry of a special plea.
Well, I guess I would suggest at this very early stage, since we're coming up with these questions at a very early stage, we're trying to cast a wide net anticipating potentials, right, that might not be relevant.
So while it's true that the jury questionnaire is being in part utilized to help the court and the parties assess the change of venue request, these also have a dual purpose in jury selection. Jury selection and the use of questionnaires being utilized to assist the court and the parties in determining whether there are any bias of any individuals. And I am not sure how any of these relate to that when there's not the entry of a special plea book.
At this point, the defense is still investigating all avenues of potential defense. We don't know quite yet exactly which avenue we're going to take because it is still so early in the case. So there has not been an NGI plea entered as of yet. There may be in the future. We don't know that yet. So again, we're looking to try to catch any and all potentially relevant issues now so that we can determine whether they might be issues going forward. When we were drafting these originally as well, we weren't sure if there's going to be another opportunity to ask similar questions. Depending on if or when this trial is going to happen, we may need to send out additional questionnaires in the future. I don't know if that's going to be something that is available to any of the parties. So at this point, we are wanting to try to ask as many questions as possible to try to get to bias in addition to the change of venue impartial jury issue.
But I also don't want to insert issues that aren't relevant either. And even if that's true, right, that you haven't made a decision on all possible defenses for which to pursue, 41 has no relevance, even if there's a special plea. The status of any treatment anyone receives would not be relevant. And that's based on even if there is a bifurcated trial and a two-phase trial. So I would not allow 41. What is the state's position, though, on including the other ones?
I agree with the court and I agree with the defense. I would suggest, Judge, at this point, let's leave it in because we don't know when these are going out and where we'll be in the case at that time. So I think for a rough draft, a starting point, it's probably better to have more and take out what we don't need shortly before them actually going out.
Does that include 41 on page 8?
No, I agree with you about 41. That was one that Attorney Basie and I had both questioned early on as to the relevance. But, I'm not filing a specific challenge to it, but it does seem irrelevant. And the one about the brain development as well. I think that was from the Slender Man case, and I don't know that it has much to do with this case, but.
Right, that had to do with, my opinion, the uniqueness of that case and the age of the defendants. What's the defense position on 45? I'll keep the other ones in, excluding 41. I don't believe there's any relevance to that, but what about on 45?
Again, we believe that it's important to try to include as much as we can to get at different ways that people think about things, to get at potential bias or partiality. But it's not a hill I'm going to die on. So if the court wants to delete it, then we can delete it.
I'm also going to strike 45 at this point. I don't believe it's relevant. I had more of a general question. I know in this questionnaire we identify some of the community participants, if you will, who have been impacted by this event, including the Waukesha School District. My general question is, if we're going to identify that, that's on page 12, asking about if there's any children who attend school within the district, any desire to also include some of the more specific groups that were, for example, the individuals who were killed, any of those groups, Dancing Grannies, the Extreme Dance Team, any specific questions on that? And if so, I would you all know this case probably better than I, and some of the specifics, you'd have to tell me what that list would be. So from the defense, is there any benefit to that, any request as it relates to that?
Sure, we did not think of that, but that could be a helpful question to ask for specific impact.
From the state?
I don't object. I had thought of it, Judge. My reason for not including it was that I, again, didn't want to draw attention to a topic or cause somebody to go research something, because we asked multiple times, do you know anybody who was at the parade or was hurt or injured? So I would assume if they're affiliated with these organizations, we'd capture their answer in those questions, but I don't object to it.
Would it be groups other than,
I can give you a list of the groups, Your Honor.
okay, thank you.
I mean, I guess the problem is, there's like 100 units in the parade, so do we want to identify all the units, or just the units where participants were physically injured, or drawing the line always becomes difficult?
I agree, but if we keep it more general, because there's a lot of very specific questions about, do you know anyone? I mean, it's asked in multiple ways, is, I guess if you're not going to identify with specificity, at least these groups that I've been talking about, do you need question 69 then?
Yes, because question 69 relates to impact beyond the incident at the parade and affected people potentially who were not at the parade because of the school closure that took place in the week following.
Understood. I agree with that. All right. If you want to submit that, and we can take a look at that, and
Of all the units?
I don't know what is the natural stopping point, right? Because you, on the one hand, you could say there's particular units where someone was, you know, killed or injured, but then there's spectators who, right, who have no affiliation with the groups, and I think those later questions deal with that. I think we would want to limit it to those groups where someone was killed or injured within the units, not all the units. But I'll certainly ask the defense what they think.
I think it's fair to limit it to the most impacted, but I am cognizant of the fact that it's already 100 questions, and we do ask about whether you know anybody who was injured or killed in a different spot, in a different way.
I'm just tossing these out as things that I thought of as I reviewed. I'm happy to defer to the parties on that, because there are many more specific questions. I mean, they're general, but they get to the information I think we're all trying to uncover.
I think it's a good idea. I think at a minimum, it should be of the groups that had specific, that were specifically directly affected by this incident. I think it's worthwhile to list them all, because then we will know which ones, in terms of sifting and reviewing it, which answers maybe on that matter more than other answers, but it would still be very valuable information to have in terms of, you know, if this ultimately goes to a jury pool that is part of voir dire, those would be things to follow up on, and so it'd be good information to get ahead of time.
And I think we can do it in such a way, even if, let's say, there's 10 different units, put them all in one question, and then put if yes, explain, so that it's not repeating multiple times. Again, I don't know all the units, but
Right, so I'm confused when defense counsel uses words like mostly affected or impacted. That's every unit in the parade was impacted by this event, you know, so.
I am defining that as a unit that had a member injured or killed,
Okay,
Yes, agree.
physically injured, not to diminish, right, other things that may have happened to people, but at least relates to the actual charges.
Yes.
Does that help?
Yes, and can I ask for permission for Attorney Basie to be able to join in on this discussion?
Absolutely.
Okay,
In terms of where we'd put that question, it seems like it'd make more sense in the area of question 88.
What page number?
I have 15, your pages may be
Thank you,
slightly
because
off.
sometimes the numbers repeat, so, because of our formatting issues.
I don't think it's on page 15.
Oh,
No, 88, question 88,
Yeah.
on page 15.
are you personally familiar?
with anyone who was injured and then anyone with affected. So I think it may make sense to put in there the groups
Or I could put it at the end.
Agreed.
or the end, yeah.
I agree with that.
Okay. So I'll provide that list to your clerk then? Is that,
Yes.
okay.
Right, 'cause what I will do ultimately, following this hearing, is work with the clerk staff to put together the questionnaire that's formatted appropriately, cleans everything up, adds or deletes as the case may be, send that to the parties for a final review, and give you one final opportunity to review what we have and make any suggested corrections or edits. I just noted a typo on page 14. It's what is numbered question 81. There's an "and," and it should probably say "any."
Yes.
Then turning to page 16. So there's question, it's numbered 77. And then, but it's really subpart E. And I would like that question to read, "Are you willing to take an oath or affirmation pledging to do so?" Rather than say vow, because that's precisely what we asked the jurors to do. Anyone have an objection to that from the state,
No.
from the defense?
No.
Number 66 on page 17. I wanted to ask a follow-up, words to the effect of, what could the court do to help or accommodate you in order for you to serve as a juror? Since I am required to provide reasonable accommodations to jurors. And so that's what that question is directed to uncover.
I'm sorry, I'm having trouble finding this one, Judge.
Sure, page 17.
Look at your printout, because I don't think the page numbers online are matching up with what's on the printout.
Right, I have a different, I made so many changes.
Oh, after 96, okay.
Yeah.
Okay,
96,
Thank you.
66, 98.
yeah, no objection to that suggestion from the court.
Same.
There's a similar question on the next page, 18 at the top. And I would like to ask that follow-up the same way. What could the court do to help or accommodate you in order for you to serve as a juror?
No objection.
Oh, it's something similar in there, you just want to change the wording?
But
Okay,
yes, I want to
yes.
be consistent in those
Yes.
two spots,
Okay,
so. Then, I know the parties had highlighted what is labeled as, I think, 100 on page 17. Of course, this is something that can be modified as the case may be. I want this to be pretty general because I need to maintain the possibility of a sequestered jury and operating Monday through Saturday.
We had a question about Saturdays, and we had removed that. So we should
I
add
think
that
I
back
just
in.
need to kind of finesse that question to say including the possibility of serving Monday through Saturday, which frankly would shorten the duration. So I think I can work on that and say something, but I don't want to, I don't want people to come in surprised, right, and say, now I'm going to work on a Saturday. You know, that's definitely a possibility, so.
Do we need to include a question then about the possibility of them being sequestered? Because that would be a surprise also.
Yes, that was my next part.
Okay.
I think maybe the next question could just simply be, you know, it is possible that jurors for this case would be sequestered and work Monday through Saturday or something to that effect. Please state any reason why you feel you would be unable to serve on this jury related to scheduling.
Does a potential jury member know what the word sequestered means?
That's a good question.
That's the next question.
Sequestered means this. How do you feel about that?
How about sequestered? Please explain. No, I'm just kidding.
I will need to probably review some of the particular jury instructions, and I'm sure I can come up with a draft, and the parties can review it, and I can work from there. I don't... I have the questionnaire from a case for which they were sequestered, and I'll look to see if there was anything in there. I don't see a question about that in that questionnaire, but I'll work on that and include it in the draft that I provide to the parties. And then, very small change, but the last question on page 17, it's marked as 81. I would just remove the word else.
Oh, I think we asked,
I think we had two questions.
right,
We had
that was
one
the,
about the math.
that was the second question in the questions about the pandemic issues, and there was one before that that asked about not being required to wear masks and whether that was going to be an issue. And then so that was then the second question, which was why the else was there.
So it was number 80 on the state's submission that said there will likely not be a mandate that everyone must wear a mask at all times in the courtroom. Would this be a factor for your serving as a juror?
Just that question should
Factor
still
or
be in there.
barrier, because the state said barrier. Do you want factor? Would this impact?
Barrier.
whatever.
Either.
Would this fact be, yeah, it doesn't matter.
Would this fact be a buried, okay, I can add that back in, and then else, the word else makes sense.
Yes.
All right. And that clarified that. That was all that I saw at this time. Was there anything else from the state that you wanted to discuss with the court on the record today?
Yes, I have a couple. I think Attorney Basie has a couple as well, Your Honor. On page, okay,
We start at the beginning.
okay, we'll start at the beginning. Just on page 1 at the very top with the name, if we could ask for complete name, like last name, first name, middle initial, and then a date of birth.
Sure.
That was in our proposed one, but it didn't get copied over. I think we missed that when we went through it this morning.
No objection.
Would that be on your proposed
Yes.
instruction numbers 1 through 7 then you want added?
Yes. Oh, and maybe 9, because mailing addresses in municipalities can be different.
Sure.
All right, so if I replace 1 through 8 on what I have with the state's 1 through
9.
10, that would be comprehensive then.
Yes.
Are the defense tracking me on that one?
I think so.
All right, any objection to that?
Could you say that again?
So on the proposed, that the court's been working off of numbers 1 through 8, I will replace with 1 through 10 on the state's questionnaire that they filed.
Okay, no objection.
All right, I've made a note of
Okay.
that.
Thank you.
And I will make sure we review everything to make sure where it says spouse, it has significant other as well. I noted maybe 1 or 2 times, but I'll make sure we look at that. I made a note.
Thank you. And then 92 and 94 on pages 15 and 16, or maybe it's 16 and 17, about, did you experience any of the following?
That's 92 on page 15.
Okay. I would like to propose at the end of that, we ask, are you still experiencing these effects?
Sure. If you answered yes to any of these questions, are you still experiencing?
And then, for both that one and 94, we would like to add in the question that we had, just a couple questions down. It's number 77, but it's still on page 16. So it goes 92, 94, 94, 77. Do you see that?
Yep.
Okay. Those D and E about, would you take, can you still be fair and impartial despite having this impact on you? And would you take an oath or affirmation to do so?
Sorry, I was still writing
Okay.
my notes, but I think I have, are you, where it says vow, you're asking that I make
Yep.
that?
D and E from 77.
I see, you want the same, yes. What do I need to change for D? Anything?
No, no, you don't need to change anything. I just want to add those same 2 questions after 92 and after 94.
Got it, after 92.
No objection.
Okay, so,
Okay,
I'm tracking now.
okay,
So duplicate D and E after question 92 and question 94.
yes. And for question 92 and 94, ask if they're still feeling the effects on the date that they're completing the questionnaire, basically. So they're asking how it impacted you,
Is it still impacting you, basically?
yeah,
Yeah.
or causing, basically, trauma.
Or how about, if you answered yes to any of the above, are you still impacted?
Yes,
Is that okay?
Sure.
And that particular question is only as it relates to 92.
oh, I think 94 also, because it's talking about, did this bring up bad memories, basically, I'm summarizing.
And are you still suffering from those bad memories?
Yeah.
Yeah.
Okay. I'll make sure as well that the formatting stays the same, and we'll use the A, B, C, D underneath, so it's very clear that it falls under a particular question. I realize some of the formatting got lost.
Yes, good luck with the formatting, Judge.
Thank you.
And covered this?
Yep.
Okay,
Does that cover everything?
okay,
Did it cover all your stuff on the list?
yes. All right, thank you. Oh, and then just one last thing, as far as naming, and we just discussed this about the victims, I'm sorry, the units in the parade, but as far as the victims are concerned and what list we provide to the jurors, the defense has requested that essentially we identify all of the victims who were included in a charged count. So that would essentially be the victim identification key. And we could certainly do that. My only concern is there are some minors on there. So I guess I'd like some direction from the court if you're giving us permission to name those juveniles or what the proposal would be.
So I think we're specifically talking about question 82 on page 14, where there would be proposed a list of potential,
Yeah.
as we're calling it, victims here for purposes of the questionnaire. So we're requesting that all individuals related to a charge in the criminal complaint are identified on the jury questionnaire.
The state's original proposal, it was question 94 on their page 24, listed various individuals. This would be a much broader list, which I agree, I believe should include individuals who are named or relate to a specific charge and identified in the victim identification key. I understand that there are minors involved, but that is important information to disclose to the potential jurors. My related question, though, to that is, should you add their parents' names as well? Because someone may know a parent, not necessarily the name of their child. And so you would have any minor, and then
Their parents.
the parents.
Would it just be the parents, or would you include step-parents then too?
I would include the parents who have legal rights to the child. So you could have someone who has a guardian and not a parent, right? So that would be appropriate to name their guardian. It might be a grandparent if a grandparent has guardianship or adopted, right? So anyone who would have some legal standing, shall we say, regarding the child, I think should also be named. What about witnesses? And I know that's an extensive list, and I'm talking about the witnesses the parties would potentially call at the time of trial.
So I think in our discussion with the defense, my understanding, they will correct me if I'm wrong, is that that list would be so extensive, we think we've covered it with other questions like, do you know any police officers? Do you know anybody that was hurt in this case? Things like that. And that certainly that will be a topic for the actual panel that is brought in for voir dire, but for this purpose, I don't think it is necessary because it would be too long.
What does the defense believe about that?
We had initially suggested all named victims and witnesses. I think that we do hopefully catch that information with other questions, and it does start to seem likely that somebody will not be thorough if it's several pages long, just listing of names. It's important to ultimately find out. I think that at this stage, we can probably accomplish what we need to accomplish with listing charged cases with victims.
Depending on when this questionnaire goes out and the posture of the case going forward, we may need to revisit this if there are experts, I think should specifically be identified in the questionnaire.
Sure.
I don't know if there's any value to identifying any lead detective.
We did do that in the one that we submitted. Oh, maybe we didn't, I'm sorry.
Not the one I have.
Okay, sorry.
You may have had that conversation, but, you know, that may be appropriate. I know we have, for example, Detective Casey here, and he's someone who's been involved from the beginning. He's testified previously. I think that, and I realize where do you start and stop, but that would be my concern if there are any expert witnesses. And then with respect to witnesses, we haven't really touched on this, you know, but for example, sometimes there's specific evidence in a case where maybe there's DNA and you want to highlight that. There are no questions really about this. And I don't need to make this a 200 question questionnaire. It's really to highlight, I think, those important aspects about the case where a juror might have a particular opinion, shall we say, that we're trying to uncover. Not to say that we won't be able to do that with jury selection. Again, we haven't really talked about this, but ultimately, right, the goal, I think, is to get, pick a number, 200, 300 out of the original to bring in for jury selection. And I think we will pick a sufficient size in order for those other questions to be asked. And I want to balance that, right? I want to get as much information. While in my perfect world, I would like all witnesses named, I realize that there are many here, and I think from my perspective, one of the primary goals of this questionnaire is to gauge the pretrial publicity and exposure to people close to this incident, and that, again, we can't put everything we'd possibly want because it would become something that the jurors might not want to fill out. at all.
I agree. This is going to take somebody an hour at least to complete, and I think that's really pushing it.
So I'm satisfied, unless the defense wants to make any more record, that naming, as we've described, victims who are associated with the victim identification key, if they are a minor, their parent or legal guardian, and leave identification of potential witnesses for the jury selection questions at the time of the actual trial.
I think that that's fine with us. I think that this questionnaire gets at the issues that we think are, most relevant to the venue question. And if the people filling this out are ultimately the jury pool that are being questioned in this case, that can all be captured at a later time.
Thank you. State agree with that?
Yes.
How about from the defense, then? Are there any other edits or questions you believe should be included that we haven't already talked about?
I don't think so. I think that we've covered them.
So I will need some time, right, to work with the clerk's office to put this in a format that is numerically appropriate, right, that looks good. Adds all of the changes that we've discussed on the record. Then I think it's also appropriate to give the parties a final opportunity to review that, file any concerns that you may have in a letter under seal, and then have a hearing to, if need be, to finalize before they're sent out. That would also give the defense time to look at whether they need to file a motion to adjourn the trial and the reasoning for that. I know we talked about getting these out by April 15th. We have time, even with an October trial date. Even if I not finalize this for another month, we have time. I want to do this right, but I also am mindful it's related to the change of venue, but I don't believe, even a 1 or 2 month delay in that is problematic in this case. I'm not giving firm deadlines just yet, but again, I want to give the parties an opportunity to review and then file any objections. And we can, at some point, there's some other things we do need to cover, but at some point we can talk about those deadlines and another hearing on that. But before I go to that, is there anything else related to these questionnaires either party thinks we need to review at this point?
I have a question about the cover letter that was going to go out, or the proposed cover letter, I guess.
Thank you.
I think both parties agree the middle paragraph, which gives details as to the exact charges, is probably too much information. Again, we're concerned about people doing research on their own or being able to look up charges and things like that. I recognize this information is available if somebody looks for it, but we just did not think it was necessary to include the exact counts and charges in that paragraph. So that was item number 1. And then item number 2 is, we do say on the second page, or in the instructions, I guess, that we will protect their information, and these questionnaires will be sealed. I'm wondering if it would be appropriate to ask them to do the same in that they do not disseminate this information. Certainly if we're going to be naming crime victims and juveniles and things like that, that they should understand that they are not free to discuss this questionnaire with anyone and, or disseminate it further, copy it, post it on social media, whatever we can come up with. But we'll respect their privacy and they should respect the privacy of the case and the individuals involved in the case.
Do you have any proposed language for the cover letter?
I can certainly work on that, Judge, of course. I really just thought of that issue as we were talking about the minors and the naming crime victims, so I can file something.
And I'm specifically referring to the letter, the cover letter, in terms of,
Oh,
like a
yes.
summary of
Yes,
the...
we do. We agreed on, I don't know if I got the right version now. Okay, the version we used in our jury questionnaire where we described the incident very generically and vaguely as, you know, Mr. Brooks is alleged to have,
61 on the state's proposed, and I think that the defense is very similar.
It's page 10, number 60 on the court's working
yes,
copy.
yes. That's it.
Small detail, but do you want his middle initial in there? It is how it is charged.
However it's charged, I guess it should be on there.
That was my belief as well. Okay? So are you proposing the language? I'm looking at page 10, item 60 on the, I guess that's the defense, but should I be looking at the state's version or the defense version?
I think we agreed that the one that we put in there was fine. I think they pretty much both stated the same thing.
So for the cover letter, I wouldn't need to put anything about because this case has
Right.
received, but that basically that there's 2 sentences, and then I would want to add to that, well, let me back up. I'd still want to say the title of this case is State of Wisconsin versus Darrell E. Brooks. This is a criminal case, not a civil case. Mr. Brooks is charged with several crimes based on the allegation that he drove his vehicle through the parade, killing 6 people and injuring many more. This case is about the Waukesha Christmas parade on November 21 of 2021. The defendant, Darrell E. Brooks, has entered a plea of not guilty to all charges. The law presumes every person charged with the commission of an offense to be innocent. And then attached is an instruction sheet and confidential juror questionnaire. The rest of that would be the same.
Yes.
Yes.
So my version just flip-flopped 2 of the sentences and then added the part about the presumption of innocence. Okay, I'll make that change on the letter. I realize there's some dates that ultimately would need to be entered in as well. And then in terms of the admonitions to them, obviously, the second full paragraph under the instructions talks about you must not discuss the questions or your answers with anyone, including any other prospective juror. I think we could put something in there about, you know, you may not or must not, shall not, however you want to put it, retain a copy of this questionnaire. you are to maintain the confidentiality of this questionnaire, words to that effect. So if you want, I can just simply work on that and include it, and then you all can review it when I send you the draft.
Thank you, Judge. Yes, that would be fine.
Anything we should specifically include, I mean, I think I want to tell them they shall not retain a copy.
Or distribute it in any way.
Right.
Yeah.
Do we want to say anything about not to comment about receiving it in any way, whether on or off the internet, something to that effect?
Yes.
Yes.
I'll take a look at the instruction 50, which is that preliminary instruction. I think there's some good language I can probably pull from there as well. I'll try to utilize. So I have, just to recap, I'll put something in there. They may not retain a copy. They can't distribute it in any way. They can't comment or discuss the questionnaire, the receipt of it in any way on or off the internet. I'll include something about social media. Am I missing anything about those admonitions the parties want from the state?
No.
From the defense?
No.
Did that cover all the points the state wanted to raise regarding the rest of the jury questionnaire, including the letter and the instructions?
Yes, Your Honor, thank you.
You're welcome. How about from the defense?
I think so, except for the big question about the trial date, which will have a big effect on this questionnaire.
Right, so for now, I'll just keep in what we have about October. The defense will need to file a motion, and again, I'll look at some deadlines momentarily. And if I receive a motion and I grant the request for an adjournment, obviously resetting the trial would require us to alter some of the questions and the dates accordingly. But for now, I'm going to keep everything as if we are proceeding in October. All right, so in addition to needing to schedule, kind of put together the timeline of when the court will have the questionnaire completed and then the review by the parties, I did send to the parties a very basic draft of a trial order. Again, I'm still proceeding, right, as if I'm moving forward because I think that's the most prudent thing to do. And if and when venue were to be changed, then I can adjust accordingly. But I do want to keep us kind of on this simultaneous tracks. I think that's important for all involved. So I want you to be mindful of the deadlines that are in that. I've utilized the trial date to kind of back up some dates. What's not in that trial order would be when the change of venue motion will be heard and a briefing schedule related to that. I sort of tipped the parties off to that previously about some additional issues I wanted the parties to cover in their briefing. I know the state hasn't been ordered to file a brief yet, and that would be part of that. Let me just look for that. I have a lot of papers up here, so.
And Judge, was that briefing taken into account that we have to receive these questionnaires back first?
Right,
Okay.
right. The parties have that proposed trial order. I just want you to all be mindful of those dates, even though I haven't entered that in yet. Again, assuming we stick with the October date, those dates will eventually be memorialized. For now, I want to just address how quickly we can finalize this questionnaire and get it out.
We do have a copy of the proposed.
I apparently can't find my copy in my many piles of paper up here, but I have different piles depending on which topic we were discussing. So, again, I don't intend to finalize that today because there are certain things that need to take place. I just want the parties to be mindful, and we can, as time goes on.
Is that something you had emailed, Judge? Or
Monica
it's not
did
in-
on my behalf.
It was emailed to us on March 22nd.
From Monica Paz.
Okay, thank you.
Do you want me to just forward it to you right now?
I remember.
I'm sorry, were you talking to me or the court?
Find it, either, I guess.
Okay.
Oh, I bet. Well, I have it up on my computer now. So. So one of the dates in there, just be mindful of, is disclosure of witnesses. I was trying to give parties ample time to review and, again, keep things moving. Because this is a general trial order, I'd like to make it part of the record so that the deadlines are there, understanding we still need to address some other issues that I will deal with a separate order. Does anyone have an issue with that from the state?
Well,
I can alter dates, you know what I mean? That's why, but
I know, it just can create busy work. So I think it'd be, from my standpoint, our standpoint, better to give a deadline for a motion to adjourn, and then if that's going to be relatively quick, I don't see the need to rush out this trial order.
and that's fine. I just may have some shorter deadlines.
Yes.
If that's not granted, and I just want the parties to be mindful of that. Okay, let's look at our calendars then.
And Judge, we will file that. The proposed dates in the trial scheduling order are not ones that I think that we'll be able to meet in terms of disclosure of expert witnesses and lay witnesses, just in terms of the volume of discovery and all the things that need to happen with the defense team. And we can explain more, lay that out in a written motion, but that's part of the calculus is looking at this and realizing that it's not realistic.
So I want to know I have my clerk of court sitting in the back, she believes we can get this, at least my draft, finalized by the end of the week with your staff. And if not, what would be realistic?
Questionnaire.
Yes. It's mostly formatting. We have the content.
I've been working on it as we've been chatting. We can get it accomplished.
All right, so I believe then I can get this to the parties by Friday. When realistically can the defense file their motion?
I think by the end of this week.
All right, so then the defense is required to file any motion for adjournment of the trial by Friday. I'm going to give a deadline of 4 p.m. That way, the staff is in the office to pull it through, and there's no delays in the state or the court reviewing it. How quickly, after receipt of that motion, can the parties be in court to address it?
Well, we need reasonable notice to the victims, Your Honor, so I would say at least 48 hours of the business day. So I
Wasn't going to make anyone work that fast.
Okay,
But
yeah,
I was thinking perhaps the end of the week.
end of next week.
Judge, I have a 2-week trial starting on the 5th.
On the 5th?
And then I'm out of the office until April 26th,
When are you gone?
April 14 through the 25th.
How about April 4th, Your Honor? Ms. Dunn indicates, even though the motion hasn't been filed yet, if we know it's set, because otherwise we're going to lose a whole month.
Right. I would have to make some modifications to the Monday afternoon. There's not a whole lot set, so that we could come in right away at 1:30. And then we'd have to cancel the afternoon for Judge Maroney.
Is there any way to leave that and do this separately or not so much?
I don't know. I'd have to look at that.
Food for thought.
There's only 2 things scheduled. Can the defense make Monday, April 4th at 1:30 work?
I have a couple other court appearances in Branch 6 at 1:30, so I could do 2.
Attorney Perry, can you do 2 o'clock?
Yes.
Can the state do 2 o'clock?
Yes.
Would it make sense then, in light of the motion hearing on the motion to adjourn, to withhold scheduling a deadline on the parties reviewing the jury questionnaires?
Yes.
I'll still do what I can to get it done by Friday, though.
Okay.
And then I think we wouldn't need to address any other dates then, since we're scheduling this pretty quickly. The one thing I would want the parties to talk about, if I do grant an adjournment request. I may just schedule the motion for change of venue then and decide it, and not wait for the jury questionnaires. Now, we've spent a lot of time and effort, but otherwise, I'm just talking out loud here, if there is a modification of that trial date, and if it's into 2023, I can't even send them out until after October 1st. I'm not saying I would not do the process, because I think there are other cases that I'm aware of, may not be Wisconsin cases, where they utilize the jury questionnaires to help decide the change of venue issue. And I think there's precedent for a court finding that the delay, even of a few months, there's a balancing that goes on, and that a court is justified in doing that. But I want to talk about that and whether I should just decide the issue and go forward from there. So be prepared to discuss that.
Okay, on Monday?
Yes.
Yes. For Monday's appearance, will you allow victims to appear by Zoom?
Oh, I'll still live stream, yes.
But I mean, if they wanted to be heard on the issue of adjournment?
Absolutely.
Okay.
Yes, absolutely. I think I owe that to them. So I will absolutely make that accommodation for them.
Okay, thank you.
If you could just let me know, that's the April, obviously, Zoom information, which the parties should have. But just let me know as best as you can ahead of time.
As to how many, the number?
And it would be nice if they do the number and have them identify themselves on Zoom with their victim identification key corresponding
Okay.
letter, I believe is how that is. Okay, anything else from the state before we conclude today?
Yeah, I just wanted to make a record as to the topic of discovery, because it's been mentioned here a couple times throughout the day, and I want the record to reflect, please, that all discovery available to the state to date has been turned over. The last large packet was turned over on March 17th of 2022. We believe the defense has the entire investigative report, including all police agencies that were involved, all witness statements, all known video recordings. On yesterday morning, Attorney Keyes filed a request for the discovery packet from the crime lab for toxicology testing. That was just emailed to them here a short time ago, about 20 minutes ago, so they now have that discovery demand complied with. To the best of our knowledge, the only thing we are waiting for at this point is DNA analysis and a report from the crime scene response unit within the crime lab to complete their work. And as soon as those items become available, they will be turned over. But I did want the record to reflect that there has been no delay in providing discovery to the defense. The initial packet was given to them at the arraignment in January, and additional materials as they've become available have been provided. But we don't anticipate large volumes of discovery that still need to be obtained or turned over to the defense.
Thank you, I appreciate that. Anything else from the defense?
I don't think so for today.
All right, thank you, everyone. We'll see everyone back here. It may very well be my courtroom. I need to talk to the clerk's office about scheduling and whether we'll be in this large capacity or up in my courtroom. I can state that every court appearance, well, there's just been 2 before me, but there's been an overflow room available. We have not needed it. We've had TVs in there, et cetera. It's been monitored, even with the potential for, I guess, more victims to appear on the 4th, given the anticipated motion. I am allowing an accommodation for them by Zoom. So I have every intent at this point to conduct the hearing in my courtroom, but I do want to talk to my team, including Zach and IT and media access and all of that. I'm mindful of that, and so that is kind of the one factor, but that is my intent at this time, is to be up in my regularly assigned courtroom. All right, thank you, everyone. We are in recess.
Oh, yeah.